Why is it now being quote unquote leaked? And are we all hearing about it? The walls are closing in on Diddy. Time is up for this man. Embattled music mogul Sean Diddy Combs is reeling after a video is leaked showing the hip-hop icon violently attacking his one-time girlfriend, Cassie Ventura. Plus, the gloves are off in the continuing murder trial of Karen Reed as the most explosive witnesses to date take the stand. And TikTok influencer Jin Kid testifies on his own behalf in a Hail Mary attempt to save himself from conviction for the murders of his wife and her male companion. All this and more this week on Courtroom Confidential. Less than 48 hours after the release of shocking surveillance footage showing a physical assault of his then-girlfriend Cassie Ventura in 2016, Sean Diddy Combs has issued an apology. In the surveillance video, Combs is seen grabbing, shoving, dragging, and kicking Ventura during an altercation in a Los Angeles hotel hallway. The video matches allegations made in a now settled federal lawsuit filed by Ventura in November of last year. Given the graphic nature, we are choosing not to show that video here, but we'll include a link in the notes. Last Sunday, Combs released a video on Instagram in which he apologized for the attack, in stark contrast to the vehement denials of any physical violence he had previously made. In response to the assault video, the Los Angeles DA's office released a statement claiming, "If the conduct depicted occurred in 2016, unfortunately, we would be unable to charge as the conduct would have occurred beyond the timeline where a crime of assault can be prosecuted." However, Diddy's problems did not end there. On Tuesday, another woman, citing a moral obligation to speak up, has sued the hip-hop mogul, accusing him of drugging and sexually assaulting her more than 20 years ago. All of this comes in the wake of a highly reported federal raid of Combs' residences in March of this year, in which many believe is related to an ongoing sex trafficking investigation. All right, well, what's happening here? First, I know a lot of you are asking, how in the world can this happen? How can you possibly have a crime caught on videotape in HD for all to see and not be able to prosecute that crime? And you may have heard a lot of talk about the statute of limitations, and that's what that statement coming from the DA's office was talking about. We have laws in this country that say that if a certain amount of time passes, you simply cannot prosecute someone criminally for what has taken place. This doesn't apply civilly. Civilly can go back decades, as we're already hearing about. But criminally, the law has decided, and it's up to the legislature in each state what that is, how long that is, but the law has decided that there's a certain period of time, and it changes for each crime, and it changes depending on the severity of the crime alleged, on how long you can extend back. I know that frustrates a lot of people, and I know that people see that as some sort of loophole of how he's getting away with it. And to some extent it is, but I think it's important to understand why that law is on the books. And what it really is talking about is, how is a person expected to defend themselves on crimes from decades, years to decades ago, when witnesses may have disappeared, evidence may have disappeared, their ability to defend themselves is decreased with the passage of time. And this is really only applies when the police should have done something about it, but they chose not to. And in this case, they're saying that, listen, this was aware, people were aware, the authorities were aware, the hotel was aware, and no one brought this forward for a period of time, so therefore it falls outside of our hands. And again, I don't know if that's going to bring comfort to any of you, but that's the way that it works. But this is far from where the story ends, especially when it comes to this videotape. Another concept we have talked about on this show a lot is the idea of prior bad acts evidence. There is no statute of limitations on that type of evidence. It's really up to the judge whether or not evidence from crimes that took place years to decades ago can be used against a person if they prove that this person has a pattern of behavior that can, for admissible reasons, be used against that person in charging them with the crime that they're now facing. I don't think this is the last that we've seen of this videotape, and I don't believe that it's the last of the problems that it's going to cause for Diddy is simply going to be from a PR perspective. I believe this videotape will play a crucial role in things that may be coming up for him in the future. And let's get into that, because the better question is not what now, but why now? Why now is this videotape being released? She entered into a negotiated settlement. That settlement, I'm sure, included an NDA. I'm sure it included whether or not this videotape would ever get out. Why is it now being quote unquote leaked? And are we all hearing about it? Put simply, the walls are closing in on Diddy. Time is up for this man, I believe. You have seen people who have turned their backs on him, people who are running away from him like rats running away from a sinking ship. They realize that this investigation, all of his bad deeds, all this history of things that we're hearing about from several different people spanning back decades and as recently as a few years ago, it's all closing in on him. And I believe that a federal indictment is coming quickly. We all talked about that raid on his home and how public that was, and that the federal investigators had to have known that that would have caught everyone's attention. There was even talk that they had given a heads up to the news organizations to fly their choppers overhead while they were conducting that raid. They knew that they couldn't make that kind of a public splash without bringing an indictment. Now, why hasn't it happened? There could be any number of reasons, and none of us know for sure except the investigators and prosecutors involved. My guess is that they recovered digital devices that are taking time for them to break into and search completely. And once all of that investigation is done, the indictments will come. I don't believe that that search, that raid on his home, was the beginning of an investigation. I think it was the end of an investigation. I believe that they already have what they want to bring an indictment. And they thought, well, we're going to search his home and make sure that we're not missing anything before we make a huge federal indictment against such a high-profile individual like Sean Diddy Combs. But what do you guys think? Do I got it all backwards? Am I completely wrong? Do you not care what good the statute of limitations may serve? Let me know your thoughts. Please leave us a comment. If the Canton courtroom was not hot enough, attorneys took a flamethrower to the witness stand as the murder trial of Boston woman Karen Reed enters its fourth week. Reed stands accused of killing her boyfriend, Boston police officer John O'Keefe, by ramming her SUV into the man before leaving him to die in a snowstorm. Last week ended with Jennifer McCabe detailing the events leading up to the discovery of John O'Keefe's body. During direct examination of McCabe, she recounted how Karen Reed pointed out damage to her taillight before immediately running to the location of O'Keefe's snow-covered body, and finally, repeatedly screaming the phrase, "I hit him, I hit him, I hit him." However, the atmosphere in the courtroom was drastically changed when trial picked up on Tuesday with a scorching cross-examination from lead defense attorney Alan Jackson. During a prolonged exchange that became highly contentious at points, Jackson peppered McCabe with questions concerning alleged deleted phone call records, conversations between prosecution witnesses that appeared to hint at collusion, and what Jackson described as an off-the-books meeting McCabe had at the home of Officer Michael Lank, one of the first officers on the scene. Kouri Roberts was next to testify. Roberts corroborated much of McCabe's testimony, recalling that she awoke at 5 a.m. on the morning in question to a phone call from Karen Reed, who was screaming frantically. Roberts told jurors that she told Reed, "You're going to get a DUI. You were drinking all last night, and you don't remember anything, you shouldn't be driving. Later, as the trio of Reed, McCabe, and Roberts approached 34 Fairview Road, Roberts testified, "All of a sudden, Karen said, 'There he is. There he is. Let me the F out of this car.' And she started kicking the door." Roberts added she didn't see anything at the time, but she unlocked the door and watched as Reed ran over to a mound of snow. Surprisingly, the defense chose not to cross-examine Ms. Roberts. This week's testimony is expected to continue with other civilian witnesses to the crime scene. All right, what's happening here? Jurors are always instructed that they are not to form opinions about a case until they begin their deliberations. And they will oftentimes hear this instruction again and again and again. Don't form any opinions. Keep an open mind. Wait until the entire case plays itself out before you start to deliberate. And as much as we hope that this is true, make no mistake, something is definitely happening in the minds of the jurors at this point in a trial. We're now getting into our fourth week. They've heard a lot of testimony. And I'm telling you this, whether they admit to it or not, they are already starting to form opinions about this case. Now, that could be opinions about the witnesses, whether or not they believe them. That could be opinions about the police, whether or not they felt that they were acting professionally or not. Or that could be opinions about the attorneys themselves. Do they like them? Do they not like them? Do they feel like they're doing a good job or not? Hopefully, they're not forming opinions directly about the guilt or innocence of Karen Reed, but believe me, opinions are beginning to percolate in the minds of these jurors. So, when you see the kind of acrimony displayed between the witnesses this week and the defense on cross, you can be sure they are forming opinions about it. And what are those opinions? Well, I'm sure that the jurors are soon going to let us know, but I will tell you this. If they have already started to believe that these witnesses are lying to them and that there is some meat on the bones to the argument that the defense is making, that there was a conspiracy here, then they may be cheering the defense every step of the way for every bit of cross, no matter how aggressive, no matter how incredulous it was at times. They may be cheering that on because no one likes to hear from a liar lying to their face, and they want to see somebody do something about it. But if they believe these witnesses, if they believe that they are doing at least their level best to be truthful and honest, they're going to look at those exchanges much differently. And they might be punishing the defense in their minds for how they're handling these witnesses. And all of that aggressiveness that you've seen people critiquing online and saying, way to go, these defense attorneys are doing a fantastic job, and go get them. And let me say this. I think the defense attorneys are doing a fantastic job. In full disclosure, I have known Alan Jackson for my entire professional career as an attorney. He was a mentor of mine. I worked underneath him at the DA's office. I worked as a law partner of his as a defense attorney. He is a phenomenal trial attorney. But this is high-risk type of trial practice. To come after witnesses this aggressively, you have to be reading the room and praying that those jurors are along with you for every step of that cross-examination. And I think Alan can do that, and I think he is reading the room. We don't have the advantage of seeing the jurors and how they're responding to all of this. So maybe he feels like he's been given license. Maybe he feels like these witnesses are giving him the permission to go after them as aggressively he is. But if he's misreading that, you can be sure that the jurors are beginning to form opinions about him, the defense team, and the defense itself. And that brings me to my last point on this. The defense has gone, in this case, way beyond saying there's no proof, the Commonwealth cannot reach their burden, and they've stepped squarely into the arena of saying, not only is our client not guilty, we're going to prove something else to you. We're going to prove to you that she was framed. We're going to prove to you that there was a conspiracy. In doing so, they have adopted their own burden. We all know this. The burden of proof lies squarely on the shoulders of the prosecution. But when the defense offers this kind of a defense, they are asking jurors essentially to put a burden on them. If it works, their client walks directly out the back door. If it does not work, it could be an absolute disaster. And that's in a case where I think that regardless of the defense that is put on, the prosecution has some major problems with proving intent. You have a woman who, by all accounts, is absolutely hysterical when she begins to realize that John O'Keefe is dead. And she is either authentically reacting to just now realizing that this man is dead, or she is a 9th degree black belt sociopath to be able to put on that type of performance to realizing that John O'Keefe is dead. But what do you guys think? Again, I feel like your opinion is far more important than mine. Let me know. What was your reaction to the defense cross? This was fireworks in the courtroom to me this week. If you've been following this trial, this was the week to be paying the most close attention to, because I believe it's the star witnesses for the prosecution and it's the star cross-examination for the defense. How do you think it turned out? Please let us know in the comments. Ali Abulaban, more commonly known as TikTok personality Jin Kid, took the stand on Tuesday attempting to convince jurors to spare him from a murder conviction. Abulaban stands accused of double homicide for shooting his wife Anna Abulaban and Rayburn Barron in the San Diego high-rise apartment the couple had previously shared together. Dressed in a black suit, his hair pulled back in a ponytail, Abulaban looked comfortable talking in front of the courtroom, often dropping swear words. As the jury appeared to listen intently and take notes, Abulaban began by detailing the abuse he experienced in his childhood, then moved on to explain how he met his wife Anna while enlisted in the military. He admitted as their relationship went on, there were times he physically hurt her, confessing to shoving and even punching her. He described their relationship as often volatile, troubled with infidelity, and drug abuse. Cross-examination is underway as of this recording and is expected to be much more focused on the actual circumstances of the crime itself. If convicted, Abulaban is looking at life without parole. All right, what's going on here? If I've said it once, I've said it 1,000 times. If the defendant is going to take the stand, they must be perfect. They can have no mistakes. A mistake in memory, an exaggeration, misspeaking about something, even something as simple as that, can be enough for jurors to say, I don't believe this person. And that is sometimes more powerful than the evidence against them. When you get up on the stand and you say, here's my story, and there are problems with that story, and the jury is able to poke holes in that story, and it doesn't look like you're being truthful with them, they almost take the lie to their faces as more offensive than the crime itself. You essentially have to knock it out of the park as the defendant when taking the stand. When I was a prosecutor, I loved when the defendant would take the stand. It was something I looked forward to because I knew that they could not help themselves into saying something wrong, into overselling the situation, into giving in to some sort of exaggeration as to what took place. I would begin cross-examination of the defendant sometimes by saying, sir, is that everything you have to say? You just testified on direct. I want to make sure that you had the opportunity to tell us everything that you feel is important for us to know. And if not, please tell us now. And you could see the beads of sweat beginning to form on their defense attorney's brow. Because now we're out of the territory of kind of coached and rehearsed direct examination. And when off the leash and allowed to say whatever they want, all of that hyperbole and exaggeration and lies start to come out. and then I get into my cross and you can just chop the person apart. Not only do you have to say everything nearly perfectly, but almost more importantly, it's how you say it. Will they like you as a person? Your explanation for what took place is one thing, but are they going to just like you and believe in you and understand you and empathize with you as a person? Or are they going to view you as some sort of raving narcissist? Which unfortunately for Mr. Abulaban is how I think things came off for him in his direct examination. He oftentimes was deflecting blame, blaming others, blaming her infidelity, how others were treating me, the abuse that I suffered from her, misunderstandings. At one point it was, we didn't get into a fight, she fell on top of me and everybody jumped to conclusions. This is not a person taking responsibility. This is a person trying to paint themselves as a victim. And I think that the jurors are going to see right through that. You cannot take the stand, try to offer an explanation, and your explanation is, I'm the real victim here. There's 2 dead bodies, sir. 2 people who lost their lives at your hands because you shot them repeatedly. Now, it's important to remember that he is not arguing for an acquittal here. He is aiming for a voluntary manslaughter, and that might be a difference maker for him. He might have a small chance there because he's saying all of these surrounding circumstances led to this moment when my emotions simply boiled over, and in the heat of passion, I did an awful, awful thing. And if he gets jurors along for the ride on that story, he might have a chance here at getting a voluntary manslaughter, which doesn't mean he goes free, but certainly doesn't mean that he spends the rest of his life in prison. Again, what do you guys think? Do you think he did well? Were you watching this trial? Is this one of those trials where you think to yourself, I don't know how to come out after hearing him testify, or were you convinced one way or the other? Tell us what you think in the comments. Before we jump into other cases making headlines this week, did you know that Courtroom Confidential is now also a podcast? Well, we are. Check us out on Apple Podcasts, Spotify, Amazon Music, or wherever you get your podcasts. Please make sure to subscribe and share us with your friends. We truly appreciate all of you in our growing Courtroom Confidential community. All right, also making headlines this week in a move that left courtroom observers gobsmacked, the team of attorneys representing a Utah woman accused of killing her husband with fentanyl, then publishing a children's book about loss and grief, have suddenly withdrawn from the case. No clear reason was publicly provided as to why Kouri Richins' private attorneys withdrew from the case, citing only an irreconcilable and non-waivable situation in a court filing this week. The request was granted after a closed hearing Monday. This development will likely slow the case against Richins, as no new attorney had stepped forward to represent her as of the date of this recording. State and county police officials descended on the home of a New York architect charged in a string of slayings known as the Go-Go Beach killings. Swarms of investigators could be seen entering Rex Heuermann's dilapidated single-family home in Massapequa Park on Long Island Monday morning. Investigators had previously searched Heuermann's home in July of last year, seizing more than 200 firearms at the time. No information has been released as to what initiated the new search or what was recovered. Heuermann is due back in court on June 18th. A New Mexico judge is considering Alec Baldwin's request to dismiss a grand jury indictment against the Hollywood star. Baldwin was indicted in January for involuntary manslaughter in the fatal shootings of cinematographer Helena Hutchins on the Rust movie set in October of 2021. In this latest motion, Baldwin, the lead actor and co-producer of the film, has argued through his attorneys that prosecutors flouted the rules of grand jury proceedings to divert attention away from exculpatory evidence and witnesses. If convicted, Baldwin faces a maximum of 1.5 years in prison. After nearly a week off, the murder trial of Christopher Gregor resumed on Wednesday. Gregor is on trial for the murder of his 6-year-old son, who prosecutors claim was killed after suffering systematic abuse at the hands of Gregor. Abuse which included Gregor repeatedly forcing the child to run to the point of exhaustion on a treadmill, as depicted in surveillance footage. The prosecution concluded their case on Wednesday with the expert testimony of a specialist in pediatric infectious disease. The expert explained to the jury that 3 physicians who examined Kouri within a day of his death found him to be a normal, healthy child except for bruising on his body, ultimately concluding that he did not die as a result of sepsis, as the defense maintains. The defense is expected to begin their case by calling renowned forensic pathologist Dr. Michael Baldwin to rebut the prosecution's claims on cause of death. Gregor himself is also expected to take the stand in his own defense. If convicted, Gregor faces 30 years to life in prison. The children of doomsday prophet and accused murderer Chad Daybell took to the stand in his defense on Monday. Emma and Garth Daybell, the children of Chad and Tammy Daybell, who Chad is accused of murdering, testified that their father was distraught and could not speak after their mother died. This week also included the testimony of a defense forensic pathologist who reviewed several documents related to the case, concluding that Tammy's death should have been ruled as, quote, undetermined, adding that in her opinion there was no anatomical cause of death. Daybell stands accused of murdering both his former wife Tammy and the 2 children of his new wife Lori Vallow. If convicted, Daybell could face the death penalty. Before we get into what's on the docket for next week, I wanted to take the time to thank you all for your support. I have to tell you that the love from our growing community has been amazing. If you haven't already, please take this time to subscribe. Make sure that you like this video. Leave us a comment. As always, we highly appreciate your feedback. On the docket for next week, disgraced studio boss Harvey Weinstein is set to appear back in court on May 29th. Weinstein had his New York convictions for rape and sexual assault overturned last month after an appellate court determined that character evidence was improperly admitted at trial. No exact date has been set, but the judge did indicate that a trial would not begin before Labor Day. And both hearings scheduled this week in the quadruple murder trial of Bryan Kohberger, the man charged in the slayings of 4 University of Idaho students in late 2022, have been postponed until later this month. According to a court order, the closed-door hearings, which were set for this week, are being delayed to allow both parties additional time to prepare. The hearings will now take place on May 30th. All right, that's it for us this week. I am your host, Joshua Ritter. You can find me on all social media at Joshua Ritter ESQ or at joshuaritter.com. Thank you again for joining me. Have a great weekend, and I will see you next week for another episode of Courtroom Confidential.